Glad to speak today, Emily. And Tuesday, every Tuesday from 5 to 6 p.m. Central Time, we do bring immigration update from Houston, Texas, and we take live questions. Emily, what do you have today to discuss?
We want to start off with an update on Texas driver's license for legal immigrants. We talked about this previously. We have new information. There's a proposed regulation for Texas to change its requirement that would mean legal immigrants have to have a valid visa stamp in order to get their driver's license, even though you don't need a visa stamp for anything else except for entry into the United States. We'll talk about what that update is, what it means, and how we can fix it if we have any ideas for that. And then big news on the birthright citizenship case at the Supreme Court. As you all know, there was an executive order day one of the Trump administration to eliminate birthright citizenship even for children of lawful immigrants on temporary visas. As expected, the court did strike that executive order down, which means birthright citizenship continues. We'll talk about what the future of birthright citizenship looks like, as Trump has already issued lots of tweets about it and what his plans are. Then we'll talk about job changes that happen during the PERM process. At what point do you have to restart the process, or when can you continue that process? And lastly, what's going on with employment-based green card interviews right now? What kind of questions to expect? Are we getting questions about why you didn't consular process based on that discretionary memo that came out last month? So all of that to discuss today.
First of all, let's discuss about this Texas driving license issue, Emily. This is becoming a major issue. So for those people who are already in Texas who have a driving license, and if they get their H-1B extension or their non-immigrant visa extension, they can use an existing Texas driving license with their passport expired visa stamping, whether it's been F1 or H1, and they can get the extension. But let's assume that I am coming from Florida to here and my passport visa is expired. My driving license is still valid in Florida. Now I moved to Texas. I can't get a driving license here because I don't have a visa stamped on the H-1B, even though I can live and I can work in the United States.
Yes, so they're claiming that under the Real ID regulations that are finally being implemented across the country, that in order to verify your identity, it's not enough that you have a passport that has your picture, has your name, has your birth date on it. You also need to have a valid visa stamp in order to verify your identity. Now, they're having no issue with verifying your lawful presence because that's also part of it. So they're only issuing driver's licenses in Texas to people who have lawful presence. So they're going to take your I-797 approval, your I-94, your EAD card, run that through the SAVE system to verify lawful presence. And none of that is dependent on having a valid visa stamp, because the visa stamp, the only purpose of a visa stamp in your passport is so that you can enter the United States. Once you've entered the United States, a visa stamp is completely irrelevant. You don't need it anymore. It can expire. But Texas says you need to have it in order for us to confirm who you really are. Otherwise, we can't give you your driver's license. So this impacts people who aren't initially coming into Texas, because if your first stop is Texas, after you enter the country, you would have likely have a valid visa stamp, so not a problem. And then for those people that got the Texas driver's license initially based on the valid visa stamp, you shouldn't have a problem renewing it, because now you can use your Texas driver's license as proof of your identity. You don't need the passport anymore for that. But for people who came to the US in another state, they're maintaining status, maybe they get a new job in Texas or their company moves them here, and their visa stamp has expired because you don't need it, you will not be able to get a driver's license. Now, initially, when this first came up, we pointed out that the Texas regulation does not require a valid visa stamp. It very clearly says valid or expired. So I've sent a letter to DPS explaining that and telling them that they're not following their own regulations. Well, guess what they did? Issued a proposed regulation to change their regulation to require a valid visa stamp. So we're in the commenting period right now. We have 30 days. So I have created a template or a sample of a comment that you can submit with instructions. It's on our website at rnlawgroup.com. So if you're in Texas or have any plans to move to Texas, I would highly recommend submitting that so we can either get them to not require a valid visa stamp or offer a second type of driver's license in Texas. There's many other states that allow a non-real ID driver's license. And so you can get that without having to go through the rigmarole of real ID and still drive in the country. You just can't use it to get on a plane. I mean, that's the only thing we need real ID for, right? Is to get on an airplane. You can get on an airplane with your passport. So why do we need the driver's license to get on an airplane? So it's all just a bunch of craziness. But the problem is because it's in the real ID regulation that's federal, means all the states are going to start moving in this direction, except for the states that are,
Democratic,
pro-immigration or exactly,
democratic
that
states.
offer that second type of driver's license. But all the red states are going to be going this direction. And it's really hard to get a federal regulation changed. We have to try to get Trump administration to
Oh, come
issue
on.
their own regulation or somehow get Congress and the Senate to pass a law that says a visa stamp's not required under what they meant by real ID. So we're really going to need big companies in Texas to lobby for this because they're the ones whose employees are not going to be able to drive to work anymore. I don't know how else we can
So,
fix that.
so Emily, based on the regulations of the real ID, I mean, technically there were some issues that were there, wrongly put in there, that they require a valid visa stamping, even though the person is staying legally in the United States. At that point of time, we did not pay that much attention because we never thought that these regulations are going to be implemented for the driving, for the purpose what they are implementing right now. But they are using that as a weapon right now so that these legal immigrants who are working in the United States don't get the visa stamping. Sorry, don't get the driving license. So definitely, definitely that's a major issue, Emily. That's a major issue right now. What are you suggesting people? I mean, don't come to Texas?
100%. Yeah. I hate to say that because we're in Texas. There are people in Texas that think immigrants offer a major benefit to our state and our country.
Hmm?
And I would like to see immigrants be able to come to Texas and be able to drive here. But if you are given the chance to move to Texas versus someplace else, don't move to Texas unless you want to deal with this whole mess. And the crazy
So,
thing is with it, having a valid visa stamp doesn't necessarily mean you're in status. You could be someone that has a passport, has a visa stamp, but is completely violating your status, and you can get a driver's license. But the person who is maintaining their status but doesn't have a visa stamp because they haven't traveled lately can't get a driver's license. It makes zero sense.
so definitely this is something not, we cannot legally address this issue. This is something that people need to lobby in. We want you to contact your companies, to contact the Texas people. They need to contact the other states. And I think so Florida is going to follow suit too. And all other red states are going to follow suit too. So, um, and definitely without driving license, I don't know. Maybe in New York, you can be okay. But here in Texas, you don't have a driving license, like you don't have a leg, or probably two legs. So because everywhere you want to go, you need to have a driving license. So so this is going to be a major issue. There are many non-immigrant people working for different companies, for Apple, for Google, for Tesla, for all these companies. They're planning to move, so they can't move into this country, or they're moving to this state. So we definitely want all of you guys to lobby to your particular companies so that they can lobby to the state government so that this regulation does not go through.
All right,
And then
next big news was the Birthright citizenship case. So we get the Supreme Court confirming that anyone born in the United States is a citizen here, regardless of the status of their parents. Is that something that we anticipated?
We
Are
we
we
definitely.
surprised by this news?
No, I'm not surprised. I was only
Mhm.
surprised. I was expecting between 8-1 or probably 9-0. We got 6-3, which is still okay. But one thing that I was very happy is that the majority opinion, not all the six people agreed with this particular thing, but at least five of them agreed on that, is that this is a constitutional issue. That means that uh, now I see the Trump, oh, we're going to try to do something. They can't, Trump cannot do anything on this one. I mean, he cannot do anything on it. It's not in the administration. It has to, and can the Congress do it? Absolutely not. The Congress does not have an authority on the Constitution. If you want to make any changes, though, it's not the majority that can change. There is a different way the Constitutional amendment can be done. Last time, when they have to change the prohibition, that means that when they want to reintroduce alcohol, the way the constitutional amendment was done and the way constitutional amendment can be done here at this 14th amendment is that they need 2/3 majority in the House, they need 2/3 majority in the Senate, and after that they have to approach the states, and out of the 50 states, 38 states have to agree to that thing. I don't think so that's happening at all for this one. At least in the political environment, it's not there. So definitely nothing is going to happen in this one. It's going to stay as it is. If anybody is going to tell you that, oh, we're going to do it, and we know who's going to tell you that. And it's going to be Trump who's going to tell you, oh, I'm going to somehow change it. No, he can't change it. He just speaks differently there. I don't know whether he understands English, Emily. Sometimes I wonder whether he understands English, which he needs to be taught that, hey, read that. It's unconstitutional. You cannot do it. It didn't say that it's the violates the Congress law. No, it does not. It's just unconstitutional. So for him, he cannot make any changes.
Yeah, but don't expect that he won't try. We've already seen him tweeting saying that he's got the perfect solution. He's going to get Congress to pass a law to change the Constitution, which, as Raul said, is not possible. We've also got several members of Congress saying that they're ready to introduce bills to eliminate birthright citizenship. Again, that only works if they do it through the constitutional amendment process. There's no way they have enough votes to get any of that done. But they're going to talk about it. They're going to be introducing legislation because all of these people, well, half of them are going to be up for reelection in November. And so they're going to be pandering to their base and claiming that, oh, we tried to pass, ending birthright citizenship and we're on, the anti-immigrant side and all of those things, knowing full well that they have no authority to do that, but they're just trying to get the votes. Unfortunately, that's kind of how we've gotten to in politics these days. So you're not going to hear the end of it, but in reality, it is the end of the issue. They cannot change it through any kind of executive order, executive action, regulation, or law. It has to be constitutional amendment.
So for those people who are here on H-1B, H-4, L-1, L-2, F-1, and other people, if you're going to, all those people who are born to you guys are going to be US citizen, or those people who are going to be born to you guys here, if they are born in United States, will be US citizens. And even if the Congress wants to pass anything, they cannot do it. They don't have the 2/3 majority, and they don't have 38 states agreeing. So that's out of question right now. It's not going to happen at all. So you're safe, guys, right now. Emily, on the third topic, what time where if there is a job change during PERM, when I'm speaking about job change, I mean to say if there is an increment in the job, um, do we need to do the PERM process again? Or can we use the same PERM? What if the I-140s are already approved? Can we just use the same thing? Or do we have to redo the entire PERM and I-140 to get the green card?
I think in most cases, you can continue the process. You can use that same perm. You can use that same I-140 to be able to file the 485. Not every case, but in a lot of cases you can. What factors do we need to look at to determine whether you can? It's number one, is this part of a normal career progression where your SOC code is the same, your job duties are basically the same, maybe your salary's increased a little bit, maybe you have a little bit more responsibilities or authority, maybe you have people reporting to you, but overall, the role and the knowledge required and the education required and the years of experience required are basically the same. You typically don't have to start that process over again. On top of that, even if it is a more major change, it depends on whether it is a temporary change. If you are working in Texas, for example, right now, and your labor certification is for Texas, but your company wants to relocate you to California so you can get a driver's license and keep going to work, but that's only temporary because they expect you eventually to come back to Texas when the driver's license thing is figured out. You can still continue that process. The whole thing is based on the future job that you will move into when you get your green card. So if that job still exists under the same terms and conditions in the same location, you can always come back to that job to complete the process, even though in the interim, maybe you went to a different location or even went to a different company. All of the process can continue in that situation. So there's been very few situations where a new labor certification is absolutely required due to a job change.
Employment-based green card interviews, what are the questions that are coming up? Nothing new questions, no new questions are coming right now, even though we have this memo that came on May 21st, 2026, that they are going to request all the adjustment of status people that why did not you go for the consular processing? We haven't seen that implementation though at all. I mean, they haven't done anything for the employment-based one or two family-based immigration people, family-based immigration, especially that are a little bit nasty cases according to our standards, did get those kind of questions asked. But in general, for the employment-based cases, the interview process is going on as usual. Nothing has been changed. What are the general questions they will ask? First thing is that how did you get this job? They're going to ask this question very thoroughly. They're going to ask you job duties. They're going to ask you to provide the income tax returns, W-2 forms, pay stubs, and everything. They are going to look into the continuous job from the time you file the 485 application all the way to right now. They're going to look into that. They may ask your employment history, your those things they're going to ask. And if you're a dependent, then they're going to ask your relationship with your spouse, any documents that you're living with a spouse. They're going to ask more documents to be shown for that. But in general, I haven't had any unexpected things going on in the employment base, not much at this point of time.
Yeah, we've really not changed much in how we're preparing the applications. We're not adding any additional documents. We've not really been discussing, why are we filing adjustment of status versus consular processing. So up to this point, everything is same as it's been, even during the new Trump administration, thankfully.
And the question that is lingering around is if there's going to be June 30th is the last day for filing the H-1B. Is there going to be a second lottery again?
That's a good question, because everything's so different this year. We obviously have the weighted lottery done. We have the $100,000 fee there, which is there, but it's not there because it was struck down, but that stayed. So at this moment, I'm leaning towards no, there's not going to be a second lottery. I do think, what we were seeing in our practice is most of the companies that got registration selected did proceed to actually file the petitions. So unless we see a massive number of denials or withdrawals or something that happens, I'm thinking there won't be a second lottery, but it is a guess because we still don't know how many they selected. And obviously we won't know how many filed for at least another 2 weeks or so, because there's definitely a delay in getting receipt notices. I was looking at our filings up to today, we've only received receipt notices in 54% of our cases that we filed, which is quite low. And I also want to just warn people that we've had a few, very small number of cases where we got receipt notices, and then yesterday and today, we got rejection notices saying that the payment actually did not go through, even though they issued a receipt notice. So thankfully, we got those yesterday and today, so we could hurry up and refile online because today is the deadline. But if any of those come after today, we may be looking at litigating because it's going to be very difficult to get them to accept a late filing that has to be refiled because of a payment issue. So just be aware of that.
Questions that are coming with regards to the 485 application. If it's an employment-based 1, employment-based 2, employment-based 3, and you have an adjustment of status, you have an EAD, which is approved, how long you're allowed to be unemployed? Technically, there's no answer to that question. It will depend on the officer, though. I definitely would like to play a conservative role. I would say that as minimum as possible, probably a weekend unemployment is probably acceptable. That means you lose a job on Friday, you get a job on Monday. It looks to be fine to me. However, if there is any unemployment longer than that time, then you will be risking getting the 485 denied if they're going to probe into the employment based. So this is there are self-employment is allowed on the adjustment of status EAD. For the primary applicant, it's definitely allowed. There's also a question that came from a person who is asking about the he has a EAD based on the EB5 application. This is Mahesh. EB5 application, he's an EAD. How long he's allowed for unemployment? Now, for EB5, the rule is quite different, though. Even though you are a primary applicant, though, you are allowed to be unemployed for a longer period of time. The For the EB1, EB2, and EB3, I would say more than 2 or 3 days is definitely a danger.
AG Suresh says, my H4 EAD has been pending for more than 13 months. It was filed May 2025, concurrently along with the H1 and H4, which those were both approved because the H1 was filed in premium. Filed an expedite request and submitted an service request online. Both were closed, saying the case is processing normally. What can be done at this point to get the H4 EAD moving forward? We are seeing the same thing as well. And really the only thing that works is litigation. That is still working and it is effective. If you want to consider that, I would say reach out to Stephen Brown in our office. You can set up a consultation with him or send him an email and he will get you the details. But that is the only thing that's working because you can't submit a service request. They're not approving expedite requests. Congressional liaison is not able to get anything moving. Litigation. The courts, clearly from today, you can see that the courts are doing their job. The checks and balances are working. Courts are still there to protect people from overreach by the executive branch, from delays by the executive branch. So use the courts.
We got a report that even in other states, they are not giving the real ID if the passport stamping has expired. Could this be a trend now that that the Democratic state may issue they're issuing a driving license, but it's not a real ID. That means that they can use that for the driving license. This is from California. Could this be a trend now that if the passport visa stamping expires, most of the Republican states are going to reject giving any form of driving license?
Absolutely. I 100% expect that's where we're headed right now.
With the political environment that they are going to attract their bases where they will say, okay, I've done so many bad things to the non-immigrants who are legally staying in the United States, and that's how they intend to get elected. So they are going to make an effort to not issue a driving license at all for the people whose passport visa is expired. So this is going to make a major trend. So definitely when you are moving to any state, you have to consider is this what you want to do? For example, in California, they are going to issue a driving license, and that's good enough for you because even though it may not be a real ID, you can fly using the passport. But for the real ID, even if you don't have a real ID, they still issue a driving license. But in Texas, they're not going to issue at all.
UO447 from YouTube says, does filing a FOIA, Freedom of Information Act request with USCIS flag your case negatively and unnecessarily increase scrutiny? Absolutely no, it does not. FOIA is processed by a completely separate part of USCIS, and it is, very clear in the law that they have to comply with it within a certain time period. Never seen any kind of negative outcome. I would not expect any kind of negative outcome. No increased scrutiny at all.
I got an I-140 with company A. Now company B also gets an I-140. Company B moved to a different location. They are filing a new 140. If the date becomes current, can company A uh, file the 485? Definitely they can. I mean, since the company A already has an I-140 approval and they can file the adjustment of status. Absolutely not a problem. Tam has this question. My date of birth is 1981, but my birth certificate was been registered in 2024 from India. A few friends of ours have some issues when the same thing happened. Not a big issue. I mean, they may issue an RFE with regards to, hey, your date of birth is 1981, you got it registered in 2024. Um, you can supplement with the additional documents. I normally supplement with two affidavits from parents. I'll also supplement if you have these following documents. If you're from India, Aadhaar card, PAN card, ration card, election card, school certificate, medical certificate from the doctor identifying the date of birth. After providing all those things, I would say we have no problem in getting any, no problem, none at all, as long as the date of birth is properly written there in the date of birth certificate, even though it's been registered date, no issues, none whatsoever at all.
Blue 12322 says, my 485 was approved in April. My wife's 485 is still in case remains pending. She is in the US, applied for her AP. Is her stay under the AOS still valid? Our priority dates are being retrogressed from tomorrow, July 1st. Yes, her stay in the US is still valid. She's in a period of authorized stay based on the pending 485. So even if you receiving your green card means you're no longer maintaining status and she's no longer maintaining her non-immigrant dependent status, that is fine. She is authorized to remain in the US and can do so the entire time, even when no visa becomes available due to retrogression.
I filed my adjustment of status. I'm waiting for the EAD and AP. It's been over 6 months since filing of adjustment of status. Can I switch the company based with a H-1B transfer without negatively impacting the adjustment of status? This is from IT Guy 007. Since it's been more than 180 days that you filed the adjustment of status, even though you did not get an EAD, I don't see any problem at all for you to change the company based on the H-1B, as long as the new job is in the similar field as what you are. So if you are in software field, if you move to a software field, I don't see any problem because you cross 180 days. The fact that you did not get an EAD and AP does not negatively impact you moving outside. It won't negatively impact you.
Raul says EB2 priority date is June 2014, AOS filed May 29th, and the case status still shows case was received and a receipt notice was sent. When can I see the status change? Well, the USCIS case status, I guess, system has very few updates. You'll get an update when they receive your case. You'll get an update if they issue an RFE, notice of intent to deny or something like that. You'll get an update for biometrics and you'll get an update for an interview. Beyond that, if none of those things happens, your case status is never going to update until it's approved. You won't see any changes. So if you're asking what the processing time is, that can be anywhere from 4 months to 18 months and anything in between, depending on whether there's an RFE, whether you're going to be interviewed, what location you're in for the interview and all of that. But that case status, you're going to see very few updates, and it's only when something major happens.
Can you discuss more about PERM alternative? This question is coming from YouTube from Nomad 10. Yes, especially when there's a lot of layoffs. One, there is a national interest waiver. If you're eligible, very less people are eligible for it. That's one thing they consider. If you have a H4 plus EAD option, please choose that. That's one thing. And let's say if your current company is not filing a PERM labor certification, can you have company B, a different company, file for the PERM labor certification? That option is there. If the PERM is been filed, but it is not been matured enough to get 1 year extension, everybody knows that even if your I-140 is not approved, if the PERM is pending for more than 1 year, you get 1 year H-1B incremental H-1B approvals. Everybody knows that. But if you're not meeting that 1 year requirement, that means that by that 1 year, you are crossing the 6 years. There are ways where you can spend time outside the country for a period of probably you can go to Mexico for 25 days and come back and keep doing that until you get that. And you know that if you any time spent outside the country will be deducted in the 6 years of the H-1B. I definitely, whatever it is, though, I want you to plan it before 4.5 years. I would say way, 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 way before. But when you touch 4.5 years, that's a big red line you're touching. 4.5 years, you have not filed a labor certification. You need to consult an immigration lawyer unless you're planning to just pack your bags and leave the country in the 6th year mark. If you don't want to, you should consult because you need to discuss those plans way earlier. Don't come to us at 5 years and 11 months and 28 days and ask what to do, because at that point of time, the solutions will be very less. But if it's 4.5 years, we may have some good solutions at that point of time. We always recommend that you do the PERM labor certification in the first year of the H-1B. But if you can't, 4.5 years is the deadline. That's a red line.
The Helidrum says, my dates are current for the past 7 months under EB1 India, and there's no movement. I'm worried about retrogression in August. What options do I have? Kind of depends on how long your 485 has been pending. If the 485 itself has only been pending for the past 7 months, then you really don't have a whole lot of options because that's not really that unreasonable in the eyes of USCIS. But if it's been pending for a year and 7 months and the priority date's been current for just the last 7 months, litigation is going to be your best option. Beyond that, if your medical exam has expired, you can submit a new medical as a way to kind of get their attention and get the case moving. If you've changed jobs, you could potentially submit a supplement J to try to get the case moving. But litigation is your best option, but the case needs to be pending for probably at least a year before it's considered to be unreasonable.
Question that is coming, can Canadian citizens on the status have issues getting driving license in Texas? Very good question. There is an exception for the Canadian nations in there, particularly the Texas proposed regulation says that if the law does not require them to have a stamping at all, then they are exempt from it. They should be giving the driving license according to the proposed regulations. So Canadian citizens, if you want to come into the United States, if your H-1B is approved, if your F-1 is if you got an I-20, if you got you don't need a visa to come into the United States. You can just come in. So you are exempt. You should not have any problem in getting a driving license, even if the new regulations goes through.
Abracadabra says, dependent traveled to India due to a family emergency, got the H-4 visa interview appointment for 2027. Will there be any issues since the primary H-1 holder is not traveling and does not have a stamped visa? In most cases, no. I mean, there is no requirement that the H-1B worker have a visa stamp in order for an H-4 to get the stamp. The only caveat would be if there's a situation where the H-1B visa stamp got revoked due to a DUI or some sort of law enforcement interaction. And then the H-4 is going for stamping. We've seen some consulates say they won't give the H-4 visa until the H-1B visa holder also goes and gets the stamp, which of course they won't get the stamp because of the DUI or the law enforcement interaction.
But Emily, in general, it's only the DUI people who has a problem, is it right, Emily, for the H4?
DUI and like people who've actually committed crimes.
Who have been arrested for any crimes.
Mhm.
Okay.
Yeah. Sabarish says, job and location change is coming up. My LCA is for Ohio and I'll be relocating to Illinois. When can I move? Is the filing of the amendment enough or do I need to wait for approval or premium processing? Filing of the amendment is enough, not the LCA, but the amendment itself, the I-129 petition needs to be filed, and then you can start working from the new work location. You don't have to wait for the approval. I would say, in general, if we were not in the Trump administration, an amendment usually does not need to be done in premium processing because you can be working the entire time it's pending at the new location. However, if you have to travel for some reason, or if there's a job loss situation and your amendment is still pending at that time, that can really throw a wrench into things. So right now, I would say premium processing, get it over with, get the approval so that it doesn't impact you in any changes that might come up in the future.
Question. Syed is asking the question, when do you think so the H1 and H4 visas will be allowed to be scheduled in the consulates in India? I don't think so. This administration has, they don't want to hurry up for sure. They're not interested in it for sure. Maybe after this administration has been changed, we can see some changes, but until this administration is there, I'm not expecting much changes.
See, it says with regards to unauthorized work by a derivative, how much detail do we need to provide when filing the 485? I generally will list the dates. I think it does partly depend on how long it was. I would say definitely discuss with the attorney that's filing the 485 to determine whether you should be concerned about this discretionary memo on the adjustment of status, because we have seen the few cases where there have been denials of a 485 due to discretion under this memo. Unauthorized employment was part of the reasoning for that. Not to say that that's happening across the board and it's a big problem, but it's just something to consider in deciding how you want to proceed with that case. But in many cases, I simply list the dates and clarify how the person still qualifies to adjust status.
She has this question, laid off from H1B, converted to B2 and applied for B2 to F1. Change of status were denied. What are my options? Can I attend the F1 visa at the consulate? Left USA immediately. You can attend the consulate. However, the problem is that since you probably were an F1 visa, you were an H1B, then you move to B2, and then you try to convert into F1 here, your chances of getting the F1 approval there will be less than 10% at this point. If it's a very good university, you will have more chances. But if it's a mediocre university, I would say less than 5% chance. Because in the F1 visa, what they're looking is that, is your intention to come study and go back to your home country, or do you think so that, or the consulate thinks so that you're going to stay in United States? That's where the problem comes in. Since you have showed that you probably came an F1, then H1B, then B2, then F1 conversion that failed, that intention is not clear for them. They may not grant you the F1 visa.
Venkata says, my son's H4 expires today. The attorney filed my H1 renewal on Saturday. Yesterday, my son's H4 was FedEx to USCIS, but still has not reached them. Can I file for him online by tonight? Yes, you can. No problem with that at all. If they both end up getting processed, you can always withdraw one. not going to be a problem. And it's a good idea to do that as a backup plan. Just when you are submitting it, take a screenshot that shows the date and time along with proof that it's been submitted. Because we've been noticing that if you file online after a certain time of day, um, your receipt notice might be generated with the received date as the following day. It's like they go off of Greenwich Mean Time or something like that. So if you don't file it by 6 o'clock, even though you've got till midnight, the receipt comes with the next date on it. And I've actually seen one RFE claiming that it was filed late. It did get approved and they had the screenshot and all of that. So that would be my only suggestion there, is to make sure you document that it was actually filed today.
This Nupur Agarwal has an interesting question, though. I am an adjustment of status EB3 EAD. If I'm unemployed for 60 days, should I leave the country? No, absolutely not. I mean, you should consult an immigration lawyer. The best thing is to consult, because it's a gray area whether you can work, you can don't work. It's a gray area, though. It's not, there is no clear definition with regards to it. It depends on the officer, a lot of different circumstances, though. And now on the H-1B, you all know that 60-day grace period is there. For on the adjustment of status, it's not there. If I were you, I'm not going to just pack my bags and leave. I'm going to still try to see to get the green card when the priority date is current.
Aziz says, my wife is on an H-4 dependent visa with an extension of stay approved till November 2028. If we get an H-4 visa appointment, and we're planning to travel, are we seeing any issues or additional scrutiny with H-4 visa stamping recently? I mean, we've been saying since January 20th, 2025, do not travel, especially if you need to go for stamping, even if it's an H-4, even if there's no issues, even if you've gotten the stamp 10 times before, there are no guarantees. They could cancel her appointment while she's out, and then there's nothing she can do. That's happened. It happened in December of 2025, and those people are still waiting for their appointments. They could change the rules while she's out. They could, they added this social media vetting. There are just so many general things that could go wrong. Unless the travel is absolutely mandatory, please do not travel right now. Do not go for stamping.
Nomad 10 has an interesting question, though. Do you think so? Do you think so? There is a fraud in EB5 or gold card? First, let me explain about the EB5 first, though. There are some frauds in EB5s, definitely, though. You have to be very careful. We, as immigration lawyers, we are not financial advisors, so we cannot give advices on the finances. We are not authorized to. So we only can look into the immigration aspects of it. Since you have that ton of money, so you are supposed to be expert, so you are supposed to explore it. So when you go to the immigration lawyers, don't trust the immigration lawyers to make a decision for you in the finances. They definitely, I have seen, I mean, I've gone to some of the Indian events and they have like 13-year-old, 14-year-old kids. They don't know what they are doing. They're just handing over the pamphlet saying, oh, you'll get a green card in 3 months. Absolutely not true. You may get an EAD in a short period of time, but the green card, it will take at least 7 years. When I say 7 years, I said 7 years. Now, don't tell me, come to me in 8 years from now, hey, Rahul, you told me 7 years. I said at least. I didn't said that it's going to take lesser than that. So why does it take that long time? First is that you have to get the I-526 approved, which is very similar to I-140. And after that, your adjustment of status will be approved. Normally, in the employment-based green card, once your adjustment of status is approved, what do we tell them to do it? You can do one thing. You can flip a burger in McDonald's. You can be a Microsoft CEO. All you do is that don't do illegal activities. That's all we tell. You're safe. Now, when it comes to the EB5, the battle just started there. You just won one battle. You still have one more battle to face to win the war, because the green card of the EB5 is only valid for 2 years. You paid all that money to get a green card for 2 years. Within the 2 years, you have to go and satisfy the requirement of the USCIS and then get a permanent green card. And that's the reason why the whole process takes a minimum of 7 years for you to get the green card. And those people who take this $800,000 from you, a good number of those people, they don't tell all the details to you because otherwise you may not put that $800,000 to them. So be careful on those things, be watchful on those things. Now, EB5, it's not that the whole EB5 is fraud. You just have to be careful what you're getting. Now, I'm only speaking of the immigration front, though. In the financial front, you also need to look into, is that management a good management? Are they frugal? Are these the people when I go into the airlines and they make me walk through the first class and business class? Oh my goodness, where do they get all this money to travel with? $1,500 ticket, they buy it $15,000. These are the people who probably are taking your $800,000 and enjoying all those luxurious business class and first class things, though. So, it's your money. I mean, they don't care about how they spend your money. Now, in my office also, I can go in business class or first class. The only thing I just have to pay for myself. The company doesn't pay me. I just have to go by myself. When it comes to these EB5s, they take your money and they're going in first class and business class. So be careful what kind of management you have. Are they interested in managing your business and growing the business? What kind of experience? Are they interested in spending and buying Ferraris on their own? So that is where you need to be very careful if the business project is going to be viable. Now, I'm not a financial advisor. I still advise you to consult a financial advisor. As far the immigration is concerned, I gave you the details.
BJ says, after the I-140 approval, I got a letter from the Department of State recently about consular processing, even though my priority date is not current for the green card adjustment of status. Is this sent by mistake? So more people are likely going to be getting these letters. It's not by a mistake. It is based on the I-140 petition. Did the form select that you are going to adjust status in the US or consular process? Because of this 485 discretion memo that came out recently, a lot of attorneys have pivoted to selecting consular process on the I-140. That does not mean you have to consular process. They're doing it so that if you do decide to consular process because of whatever this memo says, whenever they decide to implement it, that you don't have to file an extra application to convert to consular process, the I-824, which can take several months and $700, $800. So that's the only purpose behind it. You would get an email from the Department of State giving you a case number, just letting them know that the National Visa Center has received your file and that they're not going to move forward on it because no green card is available. Once a green card becomes available, you file the adjustment of status as you normally would. You can ignore that letter from that point. So more people are probably going to start seeing those just because of that change in strategy due to the 485 memo last month.
Census has this very interesting question. I got my green card. I'm planning to apply for re-entry permit. Will it have any negative impact on the citizenship? Absolutely, it will. Especially if you're planning to stay outside the country for more than 1 year, it will have a negative impact on the citizenship application. Re-entry permit is easy to apply. It probably takes a longer time for you to get it approved, but it has a lot of negative consequences. I want you to consult with an immigration lawyer. Now, I'm not telling you not to apply, but what I normally advise is apply it, get it approved, keep it in the pocket, but never use it. Only use it in emergency purposes, though. Because if you are out of the country for more than 6 months, it, if you're out of the country for more than 1 year, sorry, based on the re-entry permit, the clock resets. You will have to start the 5 years all over again for the citizenship. So that's one minus point that we have. So it will delay your citizenship, not only delays your citizenship. Sometimes what happens is that you apply for the re-entry permit, you don't get a re-entry permit, and you're outside the country. And for more than 6 months, they may not even allow you to come back into the country, though. So, especially there is a Supreme Court decision recently that said, they have more discretion in denying the people to come into United States. So be careful on those things. Until you have the re-entry permit in your hand, don't do anything. You apply it, get it, and don't use it, only use it in emergency. That's what I would advise. But either way, consult an immigration lawyer.
Pavan says November 2013 priority date, have both EB2 and EB3 485 applications pending. EB3 is current. Medicals have been submitted, but no movement. What are my options? Does litigation work? I'm assuming that your 485 and EB3 has been pending for at least a year. And in that situation, yes, litigation does work. And that's probably your only option. Because you've said you've already submitted the medicals, assuming you don't have a supplement J to submit, there's not much you can do. There's no premium processing. You can submit a congressional inquiry and they're just going to say your case is pending. There's no expedite request for a 485 application. So litigation is the option there.
I have a pending 485 with a valid EAD and advance parole. I'm planning to travel to South Padre over July 4th. And of course there is a border check post. What document should I carry? Definitely the advance parole, passport. These are definitely the documents that you need to carry. People may ask the question, where is this South Padre Island that this guy needs a passport and an advance parole? It's right in Texas, guys. And I have traveled myself a couple of times. I've been checked around. So definitely you need to carry the documents. And if you have any, let's say, for example, your H-1B extension is pending and then you're traveling there, our advice is do not travel to those kind of cities. South Padre Islands, McAllen, which is also in the south of Texas. It's a war zone there right now. But for this gentleman, though, who has an advance parole, I don't see any problem. Enjoy your time in South Padre Island. It's a nice place to go for the July 4th weekend.
Hunter says, is it safe to travel on advance parole now post the discretionary memo? For the typical employment-based 485, where you've maintained your non-immigrant status, you haven't worked without authorization, there's not been any kind of law enforcement interaction, I do think advance parole is still safe to travel on. We're not seeing results from this memo, negative results from this memo. We're not seeing 485s just randomly being denied because you filed a 485 instead of consular processing. So most people now, advance parole continues to be safe for travel.
Could the driving license rule in Texas be expanded to the other states? Shushant 60009. Yeah, very, very highly likely that it may be expanded to other states, though. It's definitely is a problem that I don't know how to find the solution right now, but it's a problem that we can identify that it is expected to spread around. That's the expectation.
Vera says, my employer is filing my H-1B transfer 2 days after the grace period ends following a layoff. What are my options to avoid being out of status for those 2 days? Not great. I think part of the question would be, do you have a valid visa stamp? And in that situation, your H-1B transfer might be better off being filed for consular processing. You exit the US to avoid those 2 days. As soon as it's approved, you come back into the US. You don't need a new visa stamp because you already have a visa stamp, even if it has an old employer's name on it, and you don't trigger the $100,000 fee because you don't need a new visa. Now, if you do need a new visa, options are even more limited. You're asking basically the government to issue a nunc-pro-tunc approval, meaning that the company has a good reason, extraordinary circumstance that why they filed 2 days late. That is discretionary, and we are not seeing USCIS officers use their discretion to benefit you. Most of the time, they're denying those nunc-pro-tunc requests. And when they do, if you do not have a valid visa stamp, they're also going to say that the company now has to pay the $100,000 fee. So that's a pretty big risk to take. The typical options would be to file a change of status. If you have H4 as an option, that's a good option, but then you probably need to wait till the H4 gets approved before you file the change of status back to H-1B. B2 used to be an option, not really a great option now. And again, you would need to wait for that approval before you file the H-1B to be on the safest footing possible. And that's typically not happening.
Elias Joseph has this question, 5769 from YouTube. Is this the right time to for citizenship, or should I wait for Trump to leave office? Right now. If you are eligible for the citizenship, you apply right now. You do not delay. Not major issues with the citizenship. You can apply online. A lot of people, what they do is that they fill it online, and they have a consultation with me, and then I will go over the form and make sure everything is okay, and then let them file it online. I had no issues right now for the citizenship at all. So please file as soon as possible. Don't think that if this administration is being gone, the next administration is going to be a lovely administration, is going to come and they're going to do the red carpets. No, don't assume that thing. And because we have seen when Bush was there, things were tough for us, and we thought, okay, this is getting tougher for us. Then when Obama came in, we crowned him as a deportation king. We called him a deportation king. So things are going to get tougher in the immigration, guys. That's going to be what it's going to be. So we have to adjust to it. It's not going to, since you have an occasion to get the citizenship, get it, get over with it, get rid of us.
Jyotsna from X says the H-1B and H-4 are expiring July 6th. The H-1B was filed in premium processing on June 29th with the H-4 as well. Will I get the H-4 receipt notice by July 6th so I don't become out of status? I highly doubt it. They don't typically come that fast. Now, getting the receipt, not getting the receipt doesn't mean you go out of status, assuming that the receipt eventually comes and it has the June 29th receive date on it. What the situation you don't want to get in is July 6th comes and goes and you don't get a receipt, and instead you get a rejection because something went wrong with the H-4 or even the H-1B or something like that. Then you do become out of status and you start accruing unlawful presence. So you may want to monitor the bank account that's being used for the H-4 filing fee. They typically are deducted about 3 business days after it's received at the immigration service. So if that happens before July 6th, then you should be good to go. If you don't see that either, consider filing online to avoid going out of status in the event that the H-4 didn't actually get properly filed. And just in general, don't wait until the last minute to file anymore. And there's so many rejections happening for all kinds of ridiculous reasons. And a rejection that happens after you have lost your status or your I-94 expired, it's very difficult to overcome that.
Krishna K has this very interesting question. I have an I-140 approval with company A. I'm right now working with the company B. Does the company B has to file an I-140 right now? Is there any time bound for the company B to file the I-140? I'm assuming that your priority date is not current or not even near current. There's no hurry for the company B to file the I-140. They can file it. I mean, assuming that your priority date, let's say, is 2020, it's not going to become current in the next 5 to 10 years. So I would say at least 10 years, it's not going to be current. So the new company doesn't have to file I-140 in the next 10 years. It's only when the priority date becomes current, the company B cannot file the adjustment of status that become dangerous. But otherwise, no hurry right now to file the I-140.
Let's do it now says, can my employer file an L1A petition for me while I'm outside the US and my H-1B is currently stuck in an RFE for the $100,000 fee? Does that create a conflict? No conflict at all. You can definitely do that in order to avoid the company having to pay the $100,000 fee or being stuck waiting till USCIS decides to actually process the case.
Anything else, Emily?
Nope, we're out of time. Thanks everyone for joining us. If you have any questions or need to reach out to us, you can now reach out at our new email address, contact us at rnlawgroup.com. And as always, you can sign up for our newsletter at rnlawgroup.com and also book an appointment with us or any of our attorneys and set up a consultation there as well.
Thank you very much for tuning.